welcome everyone to what is going to be an hour of full information. The 2020 New York State Medicaid changes and the cutbacks that we're going to face in the Medicaid program, and in particular in New York's home care program. This is our firm. We have our attorneys here in Albany, Aaron Connor, my partner, who's with me today, myself, Stefan Dunkelgren, Frank Hemming, who's our primary Medicaid attorney, and Teresa Skane. And then in our New York City office, Peter Strauss, our partner there, along with Larice Phillips and Anthony Kachui. And one of the events that we host every year that this year, because of the COVID crisis, is put on hold is our Elder Law Forum. And this was going to be a big event, our 25th annual. We are going to be doing it virtually. So the virtual forum will be something where we'll follow up from today's webinar as the new rules start to roll out and we get more information on how they're going to be interpreted. As you're going to see from a lot of the changes, it's going to be subject to further rulemaking and further interpretations by the state. So look for our upcoming announcements. We will be doing the virtual forum, including our annual presentation by the New York State Department of Health and Office for Aging, Mark Kissinger and Greg Olson, and all of our other speakers. So let's get right to it, since we don't have more than an hour. And that is an analysis of the Medicaid eligibility rules that changed with the recent budget. And we rely a great deal on Valerie Bogart and the New York Legal Assistance Group. I'm going to give them a huge plug. If you don't support them, I strongly encourage you to. They do a tremendous amount of great advocacy in New York City, and they also do a strong amount of education. And Valerie has been a speaker for us at the Elder Law Forum for the past several years. And they are extremely concerned, as are we, with regard to this new legislation, that our clients, the people that we serve, will not be getting the services and the care that they need through the new Medicaid program once these cuts go into effect. And let's talk about that. The budget bill passed, the law passed, we have the statute to deal with, but the effective date is put off. And that's something that we're going to talk a great deal about because it creates opportunity. The Families First Coronavirus Response Act, big name, was signed into law in Washington. And what that did was gave New York a carrot, $6.2 billion. And in order to get that $6.2 billion, New York has to keep its Medicaid program consistent as it was on January 1st. So that has forestalled the implementation of the budget bill changes. And if you've been listening to Governor Cuomo's pressers, as I have, and he's been doing a fantastic job of it, you'll know that he was not happy with Chuck Schumer and what Congress did in putting off the implementation of these Medicaid changes. So right now, to get that $6.2 billion, it looks like these rules will be put off until October 1st. So we have a period of time, an opportunity, one might say, before those new rules go into effect. And so with regard to that, we're going to talk about the current rules versus what will come on October 1st or perhaps later. But the big question is, will what we do today between now and October 1st be grandfathered in? So they can also extend it further, the Director of Budget, for 90 days beyond October 1st if we are not yet through the crisis. So we have now a 30-month look back we're going to talk about. We have other eligibility rules. If we get an application filed prior to October 1st and we get the application in and approved, is it grandfathered in? That's going to be one of the major questions. NYLAG believes that it is, that the eligibility determination as made at the initial application is going to continue to hold, and that the rules applicable to that individual are going to continue to apply. That may become murky. However, when we get into some of the rules with regard to the criteria for the awarding of hours, if, for example, you go in, do an application for home care, get awarded 8 hours, go back in and seek to increase that to 16 hours because of increased need, there are now new rules and regulations as to the severity or the chronic illness that needs to be shown in order to qualify for Medicaid. So if you do a reapplication for additional hours, or anything like that, do the new rules then come in and affect your entire case, and do you get reassessed under the new rules? All questions that we're going to have to wait for answers on, but things that you should be aware of. So Medicaid basics, we have about 360 people signed up today. Some of them are very experienced professionals, others are consumers, maybe seeing some of this for the first time. We're going to give you all of the new information, but what we're going to do is put it on a platform of existing Medicaid law. So we have two very different components to Medicaid. One is called chronic care and the other community-based services. The chronic care program is basically nursing home services. And for that, we have had a 5-year look back period since 2005. The Deficit Reduction Act, many of us may remember that. It brought it in along with new transfer penalty rules and also other punitive types of things to prevent people from getting Medicaid in the nursing home. For example, when the penalty period starts to run. We're going to give you some examples of that as we proceed. But our focus today is going to be on community Medicaid because that's what's impacted by the 2020 rule changes. So home health care, assisted living facility care, the ALP program as they call it, adult day care. We currently have no look back period and a whole set of rules that make it fairly favorable for our clients to receive care under Medicaid home care. That is all changing effective 10/1/20. Which services does this apply to? It applies to community-based long-term care services, home health services, private duty nursing, personal care services, the assisted living program, and other services in which medical assistance is designated as long-term care. So we are not talking about straight Medicaid today, where you are simply getting health insurance through the Medicaid program. We are talking about long-term care services, including CDPAP, the Consumer Directed Personal Assistance Program. So many of these run through the portal of managed long-term care. And if you remember the Medicaid redesign team 1, that brought us managed long-term care. The goal of the state was to achieve a triple aim: to improve the quality of care, to improve the experience of individuals using the care, and to reduce cost. And the triple aim is very difficult to achieve, as one might imagine, as you have increasing costs, increasing numbers of consumers, so increasing demand, and a limited amount of resources to satisfy that demand. So before the coronavirus, our state had a $6.2 billion budget deficit. After the coronavirus, with the economy turned off, hopefully temporarily, and with other costs continuing to escalate of healthcare, treating the coronavirus, New York State's budget deficit is going to expand. It's likely to expand significantly. So as it does, what will be the impact on the services that we have come to rely on? So what we're going to do now is take a look at Medicaid as it currently exists. We're going to start with the numbers, and for that, I'm going to introduce my socially distanced partner, Aaron Connor. Aaron?
Good morning, everyone. So the good news is the basic numbers haven't changed, okay? An individual receiving home care still can keep $895 a month. Obviously, that changes a little bit each year. That one is indexed. A couple doesn't get to double that amount because this is Medicaid. We don't do things like that. So they get roughly 1.5 times the individual amount. And the MMMNA, the minimum monthly needs allowance for a spouse in the community, remains $32.16. An individual on home care or community care for an asset perspective gets $15,750, same in the nursing home. And we're going to talk more later about the community spouse resource allowance because there have been some changes to that. What's exempt, okay? And when we say exempt, we mean it doesn't count for purposes of eligibility. Your house, if you live in it, all right, there is an equity cap of $893. We don't generally run into that here in upstate New York. We do run into it sometimes in New York City. An automobile, 1 per person, okay? No value limit currently. And prepaid burial and funeral services, again, no value and limit. We also have at other times encouraged people to prepay their children's burial, which is also an exempt asset. What in terms of actual assets, what's exempt, okay? So income producing property, this could be a business, it could be a rental, okay? The value of the property is excluded, not the income itself. Life insurance, if it has face value less than $1,500, which is the same as it's been since 1965, no index. And then IRA, 401k, 403b, any kind of tax-deferred retirement account is exempt if it's in periodic payment status. This is one of the areas that I thought they might go after, but the state did not do that. So those are still exempt. As we sit here today, what are the lookbacks? Well, it's still 5 years for a nursing home. No real movement to change that. And up until September 30th, 2020, unless extended, there's no look back for home care. What happens on October 1st? We get a 30-month look back. Now, Lou, correct me if I'm wrong, but the last time the look back changed, it was kind of stepped in.
It was phased in, correct?
Which currently, there's no regulation of phasing this in.
No, the regulations now apply the same rules that came in with the Deficit Reduction Act back in 2006. So back then it was stepped up over several years to get the phase in of the look back period. This is a cliff. It's coming in at 30 months.
Right.
So we will have a 30-month look back as of October 1st.
So if someone needs services, now is the time to get in, because it will be vastly different in October. And then we may be doing what we call crisis planning for these plans. That's still out of the air, but we're going to give you an idea of what that would look like in the next slide.
Okay. Thank you, Aaron. We're going to turn the camera back and let's look at the 30-month look back in penalty. What leads to these types of penalties? Well, obviously just straight out gifting. We have a lot of clients that come in and say, well, I wanted to gift to my kids, so I did that. Now, if you apply for Medicaid home care on October 1st or after, those transfers come back in. One that we very often, I should say, hit in Medicaid home care is cash withdrawals from a bank account. A lot of clients, just to get by and to survive, pay for care other than through checks and other on-the-books mechanisms. So they will take cash out of a bank account, they'll use that cash to pay for care, and then when it comes time to apply for Medicaid home care, where is that money? And for nursing home care, that always created a penalty that we had to deal with, and for home care it didn't, because, as Aaron said, there has been no look back for Medicaid home care in New York. So now with a 30-month look back, those cash withdrawals to pay for care are going to come back in, and it's going to be very hard to justify why that money was pulled out. Very rarely can you get the aid to fill out an affidavit saying, oh yeah, I received all this money tax-free. That just doesn't happen. So those are issues that we need to be aware of, our clients need to be aware of, and things that you need to deal with on the applications now, even for home care once the look back goes into effect. Money gifted to grandkids for school, for other purposes, vehicles sold to a family member for undervalue for $1. A lot of people say, well, I sold it for $1. Well, if it's worth $10,000, then you gifted $9,999 and you sold it for $1. And that gift would be a countable gift. There are a lot of exceptions to the transfer rules. We're going to walk through some of those. You can transfer to a spouse. You can transfer to a disabled child. The home has certain other eligibility transfer exemptions. We'll cover those in a minute. But let's look at the penalty. A lot of people don't understand the nuance between the look back and the penalty. For nursing home care, we've had to deal with that since forever. There has always been a look back and a penalty for nursing home services. When I started my career, it was 2.5 years. Then it went to 36 months. Then it went to 60 months. And so now we have those same rules for Medicaid home care coming in October 1st. Let's take a look at an example and see how that penalty is calculated and how it's going to apply under the new Medicaid home care rules. We have in upstate New York, in the northeastern region, what they call an average regional rate, a number, a divisor that the state gives us each year that we then use to calculate the penalty period. So when you give assets away, in this case, our example says we gave away $135,540, a number I picked out of a hat. No, it's a number that equates. If we divide that by our divisor, our average regional rate of 11,295, that then gives us the penalty period, 12 months. So if I give away assets of $135,540 today, and then on October 10th, I go and apply for Medicaid, they're going to look back 30 months. They're going to see my transfer of $135,540, and they're going to assess me a penalty of 12 months where I will go without Medicaid. Now, if I make that transfer today and apply in May, there is no look back period, and consequently, no penalty for the transfer. So the question then becomes, when does that 12-month penalty, that hanging penalty for the transfer within the 30-month look back, begin to run? So these are some of the regional rates. If you're following us from New York City, you're at $12,844, Long Island, $13,407, the Hudson Valley, $12,805, and here in the Northeast region, Albany and the surrounding areas, $11,295. So the penalty period in a nursing home case is much clearer, but in a home care case, what we're looking at in terms of when the penalty begins is when the individual is otherwise eligible for Medicaid and would begin receiving services if not for the penalty period imposed on the transfer. Remember, we can keep, as Aaron indicated, $15,750 as our resource allowance. So if we start with $15,750, then we have to look at getting down to that in order to be otherwise eligible for Medicaid. So everything else has to be either gifted or spent down, and if it's gifted, it's going to generate additional penalties. So this is something that you wrestled with for years for nursing home care. Now the same wrestling match will be going on for home care. So eligible once the applicant meets the financial and non-financial requirements of Medicaid eligibility. Well, doesn't that throw a little bit of added spice in? When we look at the nursing home rules, this came in DRA 05. You had to be otherwise Medicaid eligible. So again, down below $15,750, you had to be in the nursing home. There's the difference. Well, if you're receiving care at home, you're at home. You're not in a nursing home, you're at home, but are you eligible for Medicaid home care services? What does that mean? What determination has to be made? And as we're going to see at the end of the program, the criteria, the medical criteria for eligibility for home care has now shifted. So if we're applying, then you have to have a determination that you are otherwise eligible for Medicaid financially and medically, and then you filed your Medicaid application. Now you've met the three criteria. Now your penalty period begins to run. So once I have crossed all of those hurdles, I now get a penalty period of 12 months where I cannot receive Medicaid home care services. Think about what you have to go through just to get that determination. You have to be eligible financially, you have to be eligible medically, you have to file your application, you have to be deemed eligible, then your penalty period from that point begins to run. So applications after 10/1/20, 2.5-year penalty. Can we preserve assets above the $15,750? And here's where we're going to go down the path of the current law versus the future law. And we're going to start with an example using the rule of halves. Can we give away assets and still have an opportunity to pay during a penalty period? And the answer is yes. We can gift assets, and there are mechanisms we're going to talk about where we then can have assets used to pay. Typically, it's called a promissory note that is used in New York State. Other states use annuities for this purpose. but roughly speaking, we call it the rule of halves or the half a loaf theory. And you can, even at the point of application, post October 1, still preserve some assets. And let's look at an example on how that works. The example of Bob A. Bob has $3,344 a month of income. Income is important. We'll talk about how that's going to play out. $262,340 of non-exempt assets and home care costs of $9,000 a month. Now, you may say, wow, that's a lot of money, $9,000 a month for home care. $25 an hour is a pretty average cost for home health aides. And 12 hours per day of care is needed, $25 per hour, $300 per day, 30 days in the month, $9,000 is our care cost. So Bob takes those assets, or his family and Bob together, and they spend down. They buy him things like a television, clothing, a home communication system, and we're going to talk a little bit about that towards the end. During this COVID crisis, communication through various home care settings, assisted living settings, nursing home settings, hospital settings has become absolutely critical. And investment in technology is something that you'll see the state is promoting. Telemedicine has become a real staple now in healthcare. It's ingrained now in the Medicaid program. It has been, but through this legislation, it's enhanced. So technology and telemedicine will be part of things people may be asked to pay part of to get equipment and things in the home. So that can be part of your spend down. Non-exempt assets then, after the spend down and legal fees, we did include in there, the assets are $228,750. So how much of that $228,750 can Bob save if he's in a home care setting post October 1? In this case, we're going to make a gift, and we're going to gift to a trust. The trust is called the Medicaid Asset Protection Trust, and once gifted into that trust, the assets are no longer countable for Medicaid purposes. So he's also going to do a loan. He's going to loan $77,439 to Robert Jr., and he does all of that on October 28th of 2020. When would Bob then be eligible for Medicaid, and what's the result of the plan? So his income of $3,442, we would deduct his income allowance. As Aaron indicated, $895 per month is what you're allowed to keep, and we would have a net income of $2,547. So we're going to apply that $2,547 toward the cost of his care, and that leaves a shortfall in what he's paying on a monthly basis of $6,453. He now has the assets that he's looking to protect, and we're going to do the gift of $135,560. That's going to result in a 12-month penalty. We're going to loan the $77,439 for a 12-month promissory note, paying back $6,540 or $453 per month. A little dyslexic today, right? And that's for the next 12 months. So we're going to apply for Medicaid then November 1st. The gifts and loan are done October 28th. November 1, we file. The penalty period runs from November 1st to October 31st of 2021. The note pays privately for the care over that time period, and he is Medicaid eligible as of November 1, 2021. For those of you who have practiced in this area or been involved in this area, you know that this calculation has proven difficult because of increasing nursing home costs over time, and it's hard to hit the target of how much that promissory note is. That's going to be even more difficult in a home care setting because the cost of care is going to be much more volatile and is going to fluctuate a great deal more. So this is something that's going to take a great deal of skill. We're going to have to see how the state determines this because there are lines that you don't want to cross in structuring a promissory note plan. But based upon the rules, the promissory note plan is available for home care services, just like it would be for nursing home services. And now we have a trust of $135,000, the allowance of $15,750, a prepaid funeral contract, and personal property. So Bob's been able to save a significant amount of money, about $171,000. Again, a lot of variables now in this type of planning, in this calculation, and we'll have to be doing this day to day, see how it goes going forward. What happens to income? Income over $895 a month under current law can be diverted into a pooled trust. This is a major issue. This is an issue where people with disabilities, whether they're under 65 or over 65, rely on that income in the pool trust to pay their bills on a monthly basis and can't survive without that pool trust. Is now, with a penalty period applied to home care, is the viability of a pool trust in a home care context gone? And that's a question that we'll talk about today, but I'm afraid that I can't give you a definitive answer. I can tell you what the pundits think, and we can go from there. So Bob would contribute that $2547 into the pool trust, and then the pool trust would pay for things, luxuries, rent, utilities, mortgage, food, other expenses. That technology could be paid for using the pool trust income. After 10/1/20, will Bob have to live on $895 a month? Well, this issue is a very complex legal issue, turning on whether the deposit to the pool trust is a prohibited transfer under the new law. Clearly, for individuals under 65, contributions to a pool trust are exempt. We have over 93, the law way back from 1993 that brought in special needs trusts, first party, and it brought in the pool trust. Same concept. People with disabilities under 65 can contribute income and assets to a special needs trust and to a pool trust. Those are exempt transfers. Bob is not under 65, he's over 65. What are those rules? It's not an exempt transfer per se based upon over 93, but there are some other things out there, and I have to thank David Goldfarb for his analysis, which I have conveniently borrowed for today. But the resources placed in an exempt trust for a disabled individual are subject to the imposition of a penalty unless the resources placed in the trust are used to benefit the individual and the trust purchases items and services for that individual at fair market value. And that's from the CMS State Medicaid Manual. And your section is cited there on your slide. Currently, we also have a General Information Services Bulletin 08MA020, which is from 2008, which says that income of individuals over age 65 can be contributed to a pool trust without a spend down. Can we hang our hat on GIS 08020? That is the question. The answer will play out. I hope not in litigation. I hope the state comes out and clarifies that pool trusts are still applicable and that the GIS still applies, so that we will be able to keep using the pool trust for income of people over 65, even after October 1st, even after the new rules go into effect. Can Medicaid recipients live on $895 a month if the pool trust is not available? And the answer is no. Very few can live on that amount of money. They would have to get supported by family members. The caregiver burden is already extraordinary. AARP did a study of how much caregivers pay in out-of-pocket costs for their parents who need services. So this is something, how many of these people would be forced into a nursing home setting if they cannot use their income above $895 to exist in the community? Something that we'll be following closely. I think just from a realistic perspective, if you're upstate, yeah, we have some nursing home beds available, but if you're in New York City and you've got co-ops and apartment buildings full of people on Medicaid home care, and all of a sudden they're living on $895 a month, where are those people going to go? It's a situation that the numbers just won't work for New York State. So I think they're going to be forced, maybe, but compelled, maybe cajoled. We're going to be working on it, though, as the elder law section of the state bar will be, to make sure that the pool trust stays viable, because it is going to be a necessary tool for people under these new rules to stay at home. What if Bob applied for Medicaid today? How easy we have it today. And I've always said this is just a matter of time before these rules changed. We've looked at this for a long time in the Bar Association. If Bob had this issue and we get the application in for Bob today, he can get Medicaid home care. He can transfer all of his assets, all of the non-exempt assets, to that Medicaid Asset Protection Trust. He keeps his $15,750. The whole $213,000 is protected in the trust. The pool trust works. We know that today. The 2547 goes into the pool trust. His assets are sheltered. His income is sheltered. And he qualifies for Medicaid under current rules and regulations. And remember, we're going to talk about it toward the end. Those rules and regulations from a medical perspective are also changing in significant ways. So the situation today is Bob could get Medicaid relatively easily for Medicaid home care purposes and then fight the fight to get the hours that he needs through the MLTC or other processes that we'll talk about. But for married couples, Aaron, is this you?
Sure. So we see a lot of situations where one spouse needs services. Okay, so there are exemptions in the law to kind of carve out some protections for the well spouse or the community spouse. It can be called either, really. This is often under attack, which we'll talk about. So the well spouse, all right, so let's think about this in a situation where the non-well spouse or the person that needs services goes to a nursing home, all right? If they are the breadwinner, even in retirement, the well spouse gets to keep up to $3,216 worth of income. What happens there is that if that is coming from the non-well spouse, you take the well spouse's income, and the deficit between the well spouse's income and the $3,216 is what gets transferred. If the well spouse has over $3,216 worth of income, there is a, quote, voluntary contribution to the cost of care. Here, voluntary being not voluntary, but that's the way we do things in New York. So what is the community spouse resource allowance? Right now in New York, it's $74,820, or half of a couple's combined assets up to a maximum of $128,600. This is changing. As of October 1st, 2020, it will be $74,820 no matter what, okay? This is kind of a big deal. The state is going after this allowance every year, and this year they had some success in lowering it. So we don't have the availability of the higher exemption amount.
I will point out, Aaron, that in the original legislation, there was a proposal to reduce the community spouse resource allowance to $25,000.
That's right, 25 and change.
And through lobbying efforts, it was raised back in the legislature. I think Assemblyman Gottfried had something to do with that, held it steady at the $74,820, which is a much better number.
Correct.
For married couples.
Absolutely. So we use spousal refusal a lot. That's a tool that we use to try to exempt some other assets, okay? So again, if the well spouse is living in the house can be exempt. You have the $74,820, and you also have retirement assets. So there are still a lot of things that you can exempt with a well spouse, okay? Now, whether this will change going forward, we don't know, but at least for this year, we are okay. Now, the other thing to be thought of here is not every county applies the community spouse resource allowance the same. What I mean is if you refuse over $74,820, okay, let's say wife is in the community, she has $200,000. The $74,820 is exempt. The state can seek contribution towards the cost of care for the rest of it, all right? Usually, however, that's still a win for the client because the state pays less than you would pay as a private individual. So instead of maybe paying $12,000 a month, you may pay $8,000. But there are counties, certainly here locally, that don't go after any spousal refusal. So we'll kind of have to wait and see whether that changes going forward. But it still could be advantageous to be in a different county. So transfer exemptions apply to a spouse, a disabled or blind child, or a special needs trust for their benefit, or a disabled person who's over or under 65, excuse me. So spouse to spouse is always going to be exempt, all right? We're saying that these transfer exemptions, other than to qualify for medical assistance, that's always a little foggy, but hasn't been an issue thus far. And these are exemptions or transfers that have been made for less than value. Again, spouse to spouse transfer is exempt, and a disabled transfer is exempt as well. Again, when we do this planning, we transfer the house generally to the well spouse after the application has been filed and approved. The reason we do that is we are worried about recovery. We're not talking a lot about recovery today, but it's important to make sure that if there's assets in the name of a person receiving Medicaid, that they don't go through probate. These are other less used exemptions, but they have come up occasionally. A sibling who has an equity interest in a property. It's I think we've done that maybe 2 or 3 times in the 10 years or so. And this is always more of a tricky one, a son or daughter who's lived with mom or dad for 2 years and provided an institutional level of care. What we have to do there is document, and that's where the proof is really important for that transfer exemption.
Okay.
All right, I'm going to pass it back to Lou.
All right. So it's important to know what these exemptions are now for home care. They've been the same exemptions for nursing home care for years, but we didn't have a look back period until October 1st for Medicaid home care. So we have to be aware of how these rules are going to apply and know that these exemptions are going to continue for home care. We talked in the case of BOBA about an annuity or a promissory note in that case. And these are also exemptions in the statute that will continue. Using a promissory note, using an annuity, or purchasing a life estate are ways that people can shelter assets. We talked about the gift and loan strategy. So it can be gift and loan or gift and annuity in certain states. New York, it's primarily gift and promissory note. And these exemptions apparently are going to continue. So the challenges, again, are going to be to determine the first eligible month. When does that penalty period start running in a home care case? And what is the amount of the payment that you need from the note in order to pay care, but not have too much income? And that's something that will freeze the penalty period. So again, we have to really work very hard to strategize and plan and hit a target that may be a moving target with a promissory note payment that's going to fluctuate. So what can people do now? 2 camps here. One, if you are on the verge or on the borderline of needing home health care services, it's going to be to your advantage to apply before October 1st and get in under the new rules. If you're not there yet, but you or your clients have a need to put in place a plan, now we don't have the ability to get home care immediately based upon transfers of assets. We have a 30-month look back. The staple in a law practice for this is always a trust, and a Medicaid asset protection trust is what we call it. So the Medicaid Asset Protection Trust, we did a 30-minute video on. You can access it, as it says there, on our website at pierrolaw.com. But this trust is bread and butter in an elder law practice, and it's something where we have to look at the trust, how to keep it flexible, how to keep our assets protected, how to have it protected downstream for our children, and how to keep flexibility and control and access to those funds if we do need them. And all of that under current law is available, and the rules that just passed in New York are not going to impact the use of a Medicaid Asset Protection Trust. So people always ask me, well, when should I do my will? I said, well, tell me the day you're going to die, and I'll have you come in the day before, and we'll get it done. Very efficient. Nobody can do that. When should I do a Medicaid Asset Protection Trust? No one knows. No one knows because you don't know when you're going to have that onset of an illness, an accident, an injury, something that's going to render you in need of care. And now we have the same look back issues and transfer penalty issues for home care that we had for nursing home care. So we're big advocates of long-term care insurance. I think everybody should really give that another look now, because you want to have some funds available to private pay for home care especially. And you want to make sure that if you're going to do asset protection planning, you do it far enough out in advance that you get ahead of the curve, and that 30-month or 60-month look back, which is still in effect for nursing home care. So this is a critical issue, which many of us think is going to really be exacerbated by these new rules, because up until now, home care applications went in without any real financial history. You simply gave the current statements for what the income and assets were. You didn't have a 30-month history. Well, come October 1, we have to produce a 30-month history, not 60 months like nursing home, but 30 months. and recreate those financial transactions. We anticipate that it's going to create backlogs because now they not only have to triage 60 months in nursing home cases, there are far more home healthcare cases, and now they have a 30-month look back to triage at the intake point. One of our paralegals here in our firm, Jennifer DeRosa, worked at a social service agency in Rensselaer County for 10 years, and she thinks this is going to be a real nightmare for the intake people who are doing and processing the applications. Let's look at the timeline, and for that, I'm going to bring in our geriatric care manager, one of them. We have Nora Baratto and Susan Vale. Nora is with us today. And Nora, this is a timeline. I'm going to try to get us both a little bit here, although we'll distance a little bit. So this is a timeline that we've had with us for a long period of time. If we applied today for Medicaid, what can you tell your clients about when they're going to actually get service in the home?
It takes about 4 to 6 months, and it's a long process, and it really isn't for the faint-hearted. You really need to be organized. And if you, for example, file a Medicaid application with DSS on April 17th, Medicaid approves 90 days with a pooled trust. You're looking at July 16th. You request a conflict-free assessment, and that takes a while. Usually they're pretty good, but they have 7 days to conduct that assessment. And so you're looking at the conflict-free assessment being completed let's say by July 24th. And then I forgot CFA, I'm sorry. Conflict-free assessment has 2 days to send a written approval. So that takes you to July 26th. And then you contact the managed care plan and request a nursing assessment of the needs. That's done July 27th. The managed long-term care conducts the assessment of the needs, and they have to have that done by August 18th. Then you enroll, the enrollment agreement is signed with the managed long-term care plan by August 19th, and then you go to the managed long-term care plan, assigning the licensed home care vendor, and that contracts with the nursing home. So service commences September 1. So that's a long process.
And up until now, the financial piece of this was actually the easy part, because we could pretty much with certainty tell our clients, you will be financially eligible because there's no look back period. You've got to be below $15,750, and we'll set up a pool trust to get your income sheltered. This was the hard part, was actually getting the assessments, getting the care in place, finding the care providers. Now this is going to become even more difficult. So in response, Nora, they have enacted something called an immediate needs application, and that came in 2015, basically because of these delays, because how can some people who have no other resources wait 5 months to get service?
Right, and that is a process that, some of the counties were slower than others on the immediate needs process, and that really is really stressful for families. And the law requires new procedures to the process of a Medicaid application in 7 days for any applicant with an immediate need for personal care services or consumer-directed care services. And they have to approve it within 12 days. The question is, how will the new transfer penalties and look back affect the immediate needs application?
If you have a transfer within 30 months, I believe David Goldfarb, who said he doesn't think that's going to fly on an immediate needs application. And if you look at the requirements, we don't have time to detail them all today, but we can certainly give them to you and show you what it takes to get immediate needs in place. It's a difficult process because you have to have sworn affidavits as to all of the factors in place. You have to have medical forms, the M11Q, and it's a whole lot of paperwork that goes in and gets reviewed in a very condensed period of time by the county. So this has all been kicked back to the county to do these assessments, and DSS then arranges for the services under immediate needs, and within 90 days, typically you convert to an MLTC plan. But what we have found, because of the perceived inequities, if you will, in the MLTC program, most of the counties that we have applied for immediate needs in have accepted the applications, and process them on an immediate needs basis.
Right.
We haven't had any county, I don't think, reject an immediate needs application based upon failure to meet the criteria. So it has worked. It's been a good process, but with the 30-month look back, imagine triaging 30 months of financial records, bank statements, financial accounts in 7 days. Nora?
That's, families really are very overwhelmed with just gathering the financial documents. And this really is going to place a significant amount of stress on families. And, you know, I think also on the county DSS, because they've had a lot of budget cuts and, you know, they're working with less staff than they had years ago. So this is really going to be very stressful on a lot of people.
So Medicaid has a whole slew in New York. This is very unique to New York, a whole slew of home care programs. And a lot of people don't know that there are differences or what the nuances are, but this affects really all of them.
Right, right. The Managed Long-Term Care Program, that includes the Personal Care Services Program, the Consumer Directed Program, Private Duty Nursing Services. It also impacts nursing home transition and diversion Medicaid waiver program and assisted living program services.
And assisted living in New York is very limited. It's an ALP program, the assisted living program, limited number of beds. But for those people that don't need a nursing home and can't stay at home, that Medicaid assisted living bed is a valuable commodity, and there's a lot of competition for those.
Right.
They typically fill up very quickly, and only one way to open up that bed, and that's to move on to the next level of care.
Right.
So in getting care, Nora, there's also a lot of nuances in who can provide the care, what kind of care they can provide, and what people can do in the home.
Right. And for those of you out in the field, you know, personal care aide that assists with the bathing, the shopping, homemaking, and running errands, which is really valuable to keeping a lot of people independent in their own home. There's a home health aide level, which is really on the personal care in terms of bathing, dressing, toileting, and simple wound dressing. And then the nurse, which does the measuring of the vital signs, making, you know, providing the medication assistance and the medical equipment, setting that up. So there's a lot of different variations. And again, family members, we're having to teach them very fast as what the difference of those levels are.
So there's also something called the Consumer Directed Personal Assistance Program.
Yes.
And that can be used for high acuity cases because a personal assistant through the CDPAP program can do pretty much everything a nurse could do.
Right.
And so that is a big distinction. And the Consumer Directed Program has been in the crosshairs of the state. In last year's budget, there was a significant $75 million budget cut that got litigated away. But what has happened is people have found the Consumer Directed Program. It works. They've used their neighbors, their church members, their family members to provide care where they couldn't get care before. And so that is also swept up in these cuts. So the CDPAP program I just mentioned, now, Nora, we have additional medical criteria. And this is where it's really, I think, going to provide a significant hurdle to people to get Medicaid services.
Yes, and I'm especially concerned about the dementia population, but what they're requiring now is the need for 3 activities of daily living, and it says and dementia, they included dementia. Then it also says that it must be prescribed by an independent physician under contract with the Department of Health. So this physician isn't going to have that personal knowledge of that client, and that's really a critical piece because they've been the primary care physician is a physician that's been caring over time, so they have that continuity and can see and attest to what the changes have been.
And they're going to tell you that it's because we need better quality assurance and it's going to improve the system. That's bunk. What's going on here is they're stripping away the rights you have to your own physician to do a medical assessment, to put that medical assessment in the record, and to use that assessment to argue your case for the hours that you need in the home. And so we now have independent contractors. Who are these physicians going to be? Where are they going to come from? We don't know yet. They have also taken away the assessment function, and they're going to create an independent assessor. So now they said it might be Maximus. Maximus is now eligible to do both the minimum conflict-free assessment and then the conflicted assessment, I guess, with regard to the amount of care that you're going to receive. So this is going to change the dynamics of Medicaid approvals. And what we all know in the MLTC system is an already gummed up, very difficult process to get the care that you need. And it's putting in roadblock after roadblock to our clients to have that ability to get the care. Having their own physician not participate, major deal. Other things, the MLTCs, Nora?
They have a new need after October 1st, 2020, the must need physical maneuvering with 2 or more ADLs. I like when we put it in quotes because what's the interpretation of physical maneuvering? So that's a concern. Based on the interpretation, I guess. But for people with dementia and that, it says that they need at least the supervision with 1 or more ADLs. And for a lot of people that have dementia, they're usually very healthy physically, but what they need is constant verbal cueing. They can do their own ADLs, but you've got to constantly cue them in. So what's going to happen with that population? It also eliminates the housekeeping level 1 services now, which is, I had expressed as a concern because a lot of people are able to stay in their own home if they had that assistance early on.
And it becomes a preventive measure. If they're getting a minimal amount of care and staying healthier and dealing with their chronic illnesses, and now that is likely to be eliminated by these new requirements. So the treating physician, again, can't help. It has to be an independent physician. And it's also, think about that timeline, that 90 days, if you're using a pool trust, and that whole 4 to 5 to 6 month time cycle. Now you have to go out and schedule an appointment with an independent physician who is going to then do an assessment without any medical records or background, and then have to write a report and get that all into the system. How is that going to happen within the time frame? How could that ever happen with an immediate needs application?
It's going to be very difficult, extremely difficult. And even with physicians and doing that approval process, that's going to be interesting to me as well, because they also mentioned about changing the assessment.
So the assessment is going to have a new assessment tool, which is supposed to come out by, and they've been doing assessment tools at New York State, goes about 25 years. They had one 25 years ago that actually worked. It was computerized, it was fully functional, and they jettisoned it. So now we're back. So they're developing a new assessment tool, which is going to be, again, independent, and it's going to be consistent, and it's going to improve the consistency and quality of the assessment. Okay, so the Department of Health is going to put that function in the hands of an independent assessor with a new tool due to come out by April 1 of next year. So this is all new, and this is all going to change the game in the landscape for people trying to get Medicaid home care services. Again, the financial rules will flesh themselves out and will become easy to control and abide by and follow. We always follow the law. We never skirt the law, and we will do that again with these rules. But once you achieve that financial eligibility, Nora, these new rules are going to put significant hurdles in the process of qualifying for care and getting the amount of care and hours that you need. So what are your next steps? What can be done to beat the clock? Can you get your application in? If you're on the verge and you want to get grandfathered in with an application, get it done as quickly as possible. Get yourself on Medicaid home care if you think you have the need. And you must apply to get the old rules applied, both financially and medically, by September 30th. So in our firm, we have lawyers and we have care managers, and there's Nora and Susan. And what we would recommend as the next steps would be to start the process, get a good legal and financial assessment, For that, we have tools. We have a long-term care questionnaire that we make available to you, and that's on our website at pierolaw.com under the resources tab. We have guides, the Medicaid guide, which we'll send out to you as well. Those will be materials that you can get by clicking, I think, on the right side of your screen. And if you need a trust, get the trust in place as quickly as possible so you start the 30-month look back period, because remember, that's not a stagger or phased in look back, that's a cliff. It's going to be 30 months on October 1st. So the sooner you get the planning done, the sooner you create Medicaid eligibility, the better off you will be. And if you need an assessment from the healthcare perspective, if you just aren't sure, do I qualify? Does my mom or dad qualify for Medicaid? Is it something where we could file an application now and get grandfathered in? Nora, that's something that you and Susan do.
Yes, we go out to the homes and can provide that assessment.
In full PPE, I might add.
Yes. Yeah, we do that. And we also do the, the advocacy. I think advocating for the families is really a significant part of what we do.
So we have some resources available to you. Our video library, again, Medicaid trusts are on there, and a whole host of other topics that our firm does, and the guides that we have on our resource tab. And you can always find all of these on our website at pierolaw.com. And I want to thank you at this point. And that is the conclusion of our formal presentation. Again, we will be doing the virtual Elder Law Forum, and we'll be coming to you live with our speakers and our panelists in a host of settings. And we are convening a home care panel, which will include people from the consumer-directed world, from home care providers, from all of the different stakeholders in home care, to really flesh out these new rules and how they will impact you. So stay tuned for the Elder Law Forum. Courtney?
Hello, so we do have a couple questions if we want to. I know we're a little over on time, but I'd love to get your opinion on a couple of things if you've got a few extra minutes for us.
Absolutely.
Okay, so we've had a few come in. So the first one we had is, if a charitable contribution was made from an RIA, would that be part of the 30-month look back?
From an, I'm assuming that's dyslexic like me, and that it's an IRA.
Yeah, did I say that wrong? Sorry.
That's a common problem, Courtney, don't worry about it. I suffer from it all the time. So if you can make a charitable contribution from an IRA up to $100,000 per year. It's tax-free. It's embedded in the tax law. It's not a withdrawal. It doesn't even hit your adjusted gross income. It's a wonderful thing to do. And if you do that, it's a transfer for Medicaid purposes. Yes. Now, remember all of the other rules. There are a tremendous number of exempt assets and rules that can exempt transfers if you can show that this was a pattern of gifting established long before you had any health issues, and that you gave to the charity every year, or this was a gift done in advance of any illness. You had a sudden stroke or something that happened. There is a significant body of fair hearing decisions now, which have upheld the argument that the transfer was made exclusively for purposes other than to qualify for Medicaid. And that would be the tack that you want to take. That at the time I made this charitable contribution, it was not my wildest dreams that I would need or apply for Medicaid, but now I am applying, and that transfer was done for a very different purpose, exclusively for charitable purposes and not for Medicaid purposes. And that argument used to be a much more difficult one, but because of the case law that has built up over time, that's an argument that should be successful, provided the facts fall in your direction.
All right, our next question. As Roth IRAs do not require an RMD, is it considered a countable asset that must be spent down for Medicaid purposes?
You're absolutely on point and on target, and Roth IRAs don't have what's called a periodic payment requirement. This whole body of law comes to Medicaid from the Social Security law. So under Social Security, there's a program operations manual, the POMS, which includes a sentence that says a retirement account, including IRAs, 401ks, 403bs, that is in quote unquote periodic payment status, is exempt for accountability for SSI purposes, and that carries over to Medicaid purposes. That doesn't apply in many states. If you flip the border from New York to Massachusetts, Massachusetts counts traditional IRAs. Many other states count traditional IRAs. New York and Florida have accepted the IRA as exempt. What we do in a Roth case is we put it into periodic payment status. We go and we take the same table that's used. And again, this varies depending upon the county that you're in. If you're in Nassau or Suffolk County, they're using a Department of Social Services table, which forces money out much faster. Many of the other counties and HRA in New York City use an IRS table, which is much more generous to the Medicaid applicant. But we take whatever table is applicable in your county, and we send a letter to the IRA custodian saying we want to make an irrevocable designation to take required minimum distributions, although they're not required, but to take minimum distributions in accordance with the applicable table. And so far, most counties have accepted that, and they will qualify the Roth as exempt, provided you have done everything and made it look exactly like a traditional IRA.
Right. We had a follow-up to that. What about a transfer of a tax refund during the look-back period? Is this exempt?
It's a transfer. It's money. You're gonna have a check. The check is gonna hit your bank account. I would assume you're gonna deposit it, and then you're gonna write another check, or you have your refund check in your hand. I know you got it right in your hand right now. You just want to endorse it on the back and say, make this payable to my son or daughter. It's still a transfer, and it would have to be disclosed at the point of application.
Okay, next question. So how far in advance should you apply for Medicaid benefits if you are already in a nursing home and are spending down assets? How far in advance to your assets being spent down should you apply?
Well, that's a good question, and I'm going to give you a legal answer. It depends. It depends on how much money you have. So our divisor, remember the divisor for the Medicaid penalty is about $11,200. If you multiply that by 60 months, and you have double that amount of money, which would be well over $1.2 million, then what you want to do is set up a trust, put as much money in there as will leave you with enough to private pay for 5 years. If you don't have $1.2 million, then you want to apply for Medicaid right now, today, because what you're going to do is that rule of halves transfer. You're going to calculate an amount and gift it. We recommend into a trust so that you still have control over it. You're then going to do a loan, a promissory note with, say, the other half, and you're going to do a calculation. And we actually design software that does this calculation through Elder Counsel, Courtney. This is in the Elder Docs program through Elder Counsel. It does this interrelated calculation, and it will tell you exactly how much to gift and exactly how much to loan and how much that monthly payment needs to be to private pay the nursing home. But you want to apply for Medicaid right now, unless you have a huge amount of money, in which case you want to gift a good portion of that and have enough left to private pay for 5 years. But the rule of halves, the promissory note gift loan strategy is what you would do, and you would do that now and apply now. They would start the penalty period running, and remember, you have to actually be in the nursing home, otherwise eligible, so below the $15,750, which once you do the gift and loan you are, and then you file for Medicaid. That's the key. You have to file now in order to trigger that penalty and start the penalty period running.
Okay. Looks like we probably have time for one more. So they're wondering, do we know if the regulations are exempt for the folks enrolled in the NHTD waiver and who want to use the CDPAP for their home care? Hopefully I got
That's a very New York question, Courtney. So you certainly can, and we do very frequently, apply through the nursing home transition diversion waiver. In particular, and I'm going to bring Nora back for this, in particular, Nora, when we have patients with dementia, right? Because the MLTC assessment usually awards less hours than the nursing home transition diversion waiver assessment.
Right. It provides nursing home diversion program usually will provide more aid time, and it really does suit the needs better So, that is a program that I think is really going to be interesting when these new, regulations go in place, because I'm not sure that that's going to be the program that they pull back on hours for. But generally speaking, that's a better program in those circumstances.
But here's the conundrum, Nora, because we very often can't find agencies to staff
Right.
nursing home transition diversion waiver cases. So you end up pulling the CDPAC program, the consumer directed program in,
Right.
and using the consumer directed program to get the hours filled for your nursing home transition diversion waiver client. So it's clear that these new rules apply to CDPAC. Less clear how they're going to apply to the nursing home transition diversion waiver program. So it's an excellent question and a very nuanced question. We'll have to wait and see, I'm afraid, to get a real definitive answer on that one. But if you get all of this done now and you get qualified under the existing rules, I like NYLAG's position that we're going to be grandfathered in. And hopefully that grandfathering applies not only to the financial qualification, but also to the medical qualification under the current rules, which have a much lower standard in order to get the hours awarded. Okay.
All right, that seems to be about all we have for questions today. So I want to thank Lou, Aaron, and Nora for hosting. I hope you guys all found this to be super helpful, especially with all the changes that are going to be coming up. And hopefully we'll see you all soon.
Thank you, Courtney.
Thanks, Lou.
And don't forget the survey.
Yes, the post-event survey. So you guys will be seeing a survey at the end of this. We would love your feedback on today's webinar so we can continue giving you guys good content going forward. So have a great weekend, everyone. Stay safe.